Mr. Burns, you're charged with two cases. You're charged with reckless driving and unlawful carrying of a weapon. On the reckless driving, you're facing up to 30 days and or a $500 fine. And on the gun case, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 1st, 2025, at approximately 1:18 a.m., the officer observed a vehicle traveling at a high rate of speed, and the officer had to drive in excess of 130 miles per hour.
130?
Yes, Judge. And the vehicle exited from the highway, and the officer paced the vehicle bumper to bumper between 100 and 105 miles per hour. The vehicle was changing lanes and driving around vehicles that were traveling at the posted speed limit of 45 miles per hour. The officer cut up to the vehicle to get a closer read and paced the vehicle again at 92 miles per hour. The vehicle drove through a stale red light without stopping and into the intersection at 51 miles per hour. A traffic stop was conducted, and the defendant stated he was driving that way because he was on his way to his baby mama's house and that she wanted to go to the doctor. The defendant stated that he may have outstanding traffic tickets. The officer asked the defendant if he had any guns in the vehicle, and the defendant stated he did not. The defendant was arrested for reckless driving, and an inventory search of the vehicle was conducted, and the officers located a loaded semi-automatic gun found between the driver's seat and the center console. The defendant stated the firearm belonged to his girlfriend, and the defendant made further references and threats towards the officer.
Mr. Byrd, you understand that I'm going to do everything in my power to protect my public at all costs. And if that means putting you in jail and making your bond sky high, I will do it in a heartbeat. Do you understand? Yes, you are not allowed to drive, and you will be signing an affidavit with me today, promising me you're not going to drive. If I find that you do, I can have a contempt hearing every single time you drive. It's an offense in and of itself. Do you understand? And finding that there's probable cause to go forward on the reckless driving, in addition to the gun case, you're also ordered not to be in possession of any weapons as well. If I find that you have a weapon, you pick up a new case, violate conditions in any way, I will revoke your bond on both cases, put you in jail, no more PR bonds. Do you understand? Do you have the ability to hire a lawyer? You work these. What do you do with yourself these days?
I just lost my job due to this case.
Okay, I'll have you fill out an application. Deputy Rand is going to give you an application. I'll have you fill it out. I'll take a look at it. Keep my county safe. Do you understand?
So,
Come on.
Step up here, Mr. Burns.
Good morning, Mr. Frazier. Sir, you're charged with indecent exposure. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 1st, 2025, the officer was at a Texas Roadhouse parking lot in Harris County, Texas, conducting a traffic stop. While on the stop, two restaurant employees approached the officer to state the defendant had just exposed himself to them by having his car window down to be visible to them and stroke his penis up and down. The employees provided a picture of the vehicle, the license plate, and a picture of the defendant. While trying to get an accurate location of the vehicle, the defendant began approaching the employee while she was on foot in the parking lot. Two employees pointed out the vehicle getting ready to leave the parking lot, and the officer conducted a traffic stop. The defendant stated he was trying to get to a hospital for a laceration to his left leg, and the officer went inside the restaurant to view surveillance of the parking lot. The officer observed the defendant waiting in the parking lot before the complainants walked out. The defendant was parked further back than the complainants. When the complainant got into their vehicle, the defendant drove forward and parked next to the complainants. The complainants turned and observed the defendant to have a passenger window down, sitting up in the driver's seat, and stroking his penis in an up and down motion. The complainants drove off and came back to the defendant's vehicle to get a picture of the defendant and his vehicle. The defendant pulled forward again in a parking next to the vehicle with a woman facing away from the defendant. The defendant parked his vehicle and eventually drove away. The defendant drove around the parking lot and approached the complainant, who was on foot searching for him. The complainant ran away in fear of being hit by the defendant's vehicle.
Mr. Frazier, we're going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to expose yourself to anyone in this county in public. Do you understand? If I find that you do, I will revoke your bond, put you in jail. No more PR bonds for you. I'm also ordering you not to go back to this place. Where was this?
A Texas Roadhouse, Your Honor.
Okay, you're not allowed to go back to this Texas Roadhouse. Do you understand? Likewise, if I find that you go back, then I will revoke your bond. So would you reach out to them to let them know that we have put these conditions in place so that if they should see him again?
Yes, Judge.
Okay. Mr. Frazier, do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer? Okay. Deputy Miranda's going to give me an application. I need you to fill it out and I'll take a look at it. Don't be a danger to my community. Do you understand? Okay. Good morning, Ms. Ford.
Morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed for you, ma'am.
I apologize for the last name, Your Honor.
P-O-U-R.
Okay. On March 2nd, 2025, the officer was dispatched to an accident on the 4500 block of Southwest Freeway, and the defendant was passed out in the passenger seat of a tow truck. The officer noted that her eyes were low, her speech was slurred, and her breath smelled like alcohol. She had also urinated on herself. The defendant stated she had one drink and was coming from a club, and the defendant showed lethargic behavior, and the defendant confirmed that she was the driver and that no one was with her. Standard field sobriety tests were administered, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant consented to breath, and the results were 0.128 and 0.118.
Where was she driving? What was she doing? All I know is that she's sitting in a passenger seat of a tow truck. How did she get there? What happened? Was there an accident? Who is writing these reports nowadays? I mean,
Yes, Judge. And the statement made statements stating that she confirmed that this was her vehicle and she drove it through the crime scene. The defendant confirmed that she was with only her, no one else was with her. The defendant confirmed that she was on her way home from a club where she consumed alcohol. And the defendant's vehicle was found stalled on the shoulder of a busy freeway. And the officer wrote that led the affiant to believe that that there was no one else that fled from the scene. And the officer wrote from the affiant's training experience that he believed that the defendant was the driver of the vehicle based on the statements made to him and finding the vehicle.
did anyone see her drive? Did the tow truck driver see her drive? How long did she drive? When did she drive?
We don't have that information.
So it says that there was, Deputy DuPont was dispatched to a one-car minor accident and the vehicle was leaning on its side and stuck in a muddy ditch. The defendant was passed out in the driver's seat with the key inside the ignition and the engine running. That deputy
So-
woke up the defendant.
So someone sees her in a ditch.
Wait, is that?
You might have a different
Oh,
case.
sorry, that was the wrong case, Judge.
In this
Sorry.
case, she was passed out in the passenger seat of the tow truck, and there's no other information in regard to her driving besides the statement she made. So there's no one that observed it, Your Honor. And we understand.
Let's do this. I'm gonna appoint you a lawyer today so we can have someone take a look at the case for you. Okay? Ramona, do you mind appointing someone for Ms. Moore, please? Just do me a favor. Just take a seat for me in the jury box, will you, please? Okay, so it's a DWI Class B. Mr. Pons, please.
Yes, Judge. On March 2nd, 2025, the officer was dispatched to an accident call on the 4500 block of Southwest Freeway. The defendant was passed out in the passenger seat of a tow truck, and the officer noticed that her eyes were low, her speech was slurred, her breath smelled like alcohol, and she had urinated on herself. The defendant stated she had one drink and was coming from a club. The defendant showed lethargic behavior, and the defendant confirmed that she was the driver and that no one was with her. Standard field sobriety tests were administered, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant consented to breath, and the results were 0.128 and 0.118.
We have her in the passenger seat of a tow truck.
Right, so her statement alone isn't sufficient. That's all they have about her driving.
In Your Honor, in the complete OR, there's further statements that kind of clarify the time period that when this happened. The officer stated that at 7:20 a.m., that's when he was dispatched to the accident call, and he arrived at 7:21. And the defendant stated that she was on scene and she was coming from her residence from a bar called Good Mood that she had arrived at 3 a.m. And the defendant stated she had the one mixed drink only and left Good Mood Lounge at 5 a.m. when she proceeded to head home. And the officer found the vehicle on the right shoulder stalled with the front passenger tire blown out. So the encounter with the defendant took place 2 hours according after when she left the bar.
But none of that same, well, go ahead.
Have,
Go down to you.
so do we have an officer that actually sees her in the car in the ditch?
No, Your Honor, the car just found in the ditch with the tire blown out, and the only thing the officers have to put her in the vehicle is her statement saying she drove and when she left the bar.
Well, that's it then. If that's the only thing they have, no PC.
Judge,
Their statement alone can't be sufficient evidence. They need corroboration.
And the corroboration we have is that when the officers arrived, there was nobody else on the scene. There was a crowded freeway. There was nobody else who could have gone to the accident or left the accident because they were on a highway with traffic and there were no other people around.
One, I don't see that the officer said any of that. Two, that's still not gonna corroborate that she was driving.
Why are you saying that the statement, her statement in and of itself is insufficient?
That's a rule. I can give you a case if you want.
Yeah, yeah. I do.
Okay, we'll give
So-
you time.
Yeah. And I'm willing to, if you want, maybe like we can revisit on Monday
Okay.
because I want to give you time. I want to,
Wait for her appearance? For Monday?
yeah, I'm going to put her under conditions though, but yeah.
Understood.
Okay. But I'd like to do a deeper dive on the PC and I want to know, is that in and of itself insufficient? And it'll give you more time as well.
I'll reach out to the
Let's
officer.
reach out Monday and we'll do more, I guess, a formal hearing. Ms. Poor, we will have an additional hearing on Monday to determine whether there's sufficient probable cause to go forward. So you need to stay in contact with Mr. Pons and he will tell you how we went forward on Monday. As it stands now, I'm ordering you not to consume alcohol or illegal drugs while you're on bond in this case. Do you understand? If I find that you consume alcohol or illegal drugs, I'm going to revoke your bond and we'll put you in jail. Did you guys run a license, please? And any other prior DWIs?
Your Honor. No prior DWIs, and we're running her license right now.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you are not allowed to drive. Do you understand? Okay,
Possible, Your Honor.
great. So for now, I'm going to have you sign a reset with Ramona. We're going to set it for Monday. You don't have to be here. No. We're going to waive your appearance, but Mr. Pons will let you know how everything transpires on Monday. And then after you sign a reset, I'll have you meet with Felicia if your bond conditions, and after that, you'll be free to go. Okay? Okay, Mr. Pons. Thanks.
Okay, thanks.
See you Monday.
So she needs to meet for bond conditions.
Yeah, she needs to sign a reset, but yeah.